Yes.
supplementary examination hall and write the examination. You did not permit it. We will set aside this. And second matter was, since linked on the same day, we will say that although there is no flaw, both were listed here in that also.
Lordship
Will
may,
not cause any prejudice to you.
Your Lordship may record that the department has done everything
We
in
will say
accordance.
so.
I'm
In the first
grateful.
matter, we will say so that although there is no serious flaw on which interference is made, but since both the matters were listed together and nature of inability shown by the council is same, in the fitness of thing, we do it.
My humble submission, I don't think that is a ground, my lord, for lordship to intervene. However, I leave it to my lords, my lord, to your lordships.
Had it been a stray case, not listed for analogous hearing, perhaps what you are saying, we would have accepted it.
My lord, it's
But
not
it was
listed.
listed on the same day.
My lord, it's listed on the same date, my lord, but
Council was common. The inability was that he is arguing some bail matter, therefore please adjust
no,
me.
but it was not brought to the notice of the department at all, my lord, in the second case. So second case technically goes, my lord, because there is nothing on record to show that he's approached. In fact, your lordship has seen the email ID also. He only talks about first appeal. Party names are different. Appeal numbers are different. But just because
We'll
the
say that
council,
you are right, but still both the matters are listed.
I leave it to my
We
lord.
will not find any fault so far first matter is concerned, but
Yes.
in broader way, in a holistic manner, because both the matters were listed, we will permit them to argue.
I'll leave it to my lords, my lord.
Do you have any objection if you allow your petition?
My lord, I will highly oblige, my lord.
You say such and such for the petitioner, say such and such, with the consent finally heard. If I am fast, please tell, that go slow. WP number 26904 of 24. This petition filed under Article 226 of the Constitution takes exception to the order dated, which is the order? Order dated 19/7/20, appellate order dated 19/7/24. The singular ground of attack to this finding is, to this order and decision-making process is relating to not providing the personal hearing through video conferencing mode. During the course of hearing, during the course of hearing, there was no dispute between the parties about the genuineness of communication dated 7th June 24, annexure P6. In this communication, when petitioner, in this communication regarding date of personal hearing scheduled on 10/6/24, petitioner requested to provide him a video conferencing link on his email ID, which is mentioned in the said communication. The said request was not adhered to, and learned appellate authority passed the final order. Learned counsel for petitioner submits that in view of the CBIC instruction dated 28th July 22, whereby previous instruction dated 21/8/20 was amended, it was obligatory on the part of appellate authority to provide virtual hearing in the event any request is made by the assessee. In the instant case, request was indeed made and not granted, which for this reason alone, the appellate order may be set aside and matter may be remitted back to the appellate authority to pass a fresh order after hearing the petitioner in accordance with law. Next, Mr. Fernandes name, mentioning Mr. Fernandes.
Yes, grateful.
Dominic Fernandes supported the impugned appellate order and urged that as per section 75(4)
Yes, my lord.
of the GST Act 2017, three opportunities of personal hearing were required to be given to the assessee. In the instant case, admittedly 3 opportunities were granted to the petitioner. In addition, one more opportunity was granted and matter was fixed for personal hearing on 10/6/24. The complaint of petitioner is in relation to this hearing scheduled on 10/6/24. This was 4th hearing and therefore even otherwise the even otherwise video conferencing facility was not provided to the petitioner, it will not cause any dent to the appellate order because statute requires only 3 opportunities to be given which were admittedly given. Next, we have heard the parties on this aspect and peruse the record. Next, the fourth opportunity, when third opportunity was granted to the petitioner for a date, what was that date? 6/6/24 for the hearing date on 6/6/24, counsel for petitioner. The petitioner made a request of adjournment because counsel engaged was busy in Faridabad District Court. The respondent did not close the matter there itself. They granted another opportunity and fixed the date on 10/6/24. The petitioner on 7/6/24, annexure C6, made a request to provide video conferencing link which has not been provided to the petitioner. Since respondent themselves thought it proper to provide another opportunity of personal hearing on 10/6/24, when petitioner's request was received, in consonance with instruction dated 28 July 22, the link the link of virtual hearing ought to have been provided to the petitioner. The said circular reads thus. This flagging this circular. Just reproduce this. The circular reads thus. Next, since respondents have, since the appellate authority has not adhered to the procedure prescribed in the circular dated 28 July 22 and principles of natural justice are grossly violated, we are inclined to, we deem it proper to set aside the appellate order dated 19/7/24. The said order is set aside. The appeal is restored to its original number.
My Lord, may I make one further request?
With the direction to the appellate authority to rehear the parties and pass a fresh appellate order in accordance with law.
Lordship, may kindly record that request was made only in one matter, my Lord, on the date of the
This
hearing.
is order only of one matter. Second, I have yet to dictate.
I'm grateful to you, Lord.
Second matter. Second matter. WP number 26884 of 24.
Yes, ma'am.
Parties to their counsel with the consent finally heard. This matter was listed today for analogous hearing with WP number 26904 of 24. Interestingly, the impugn order in both the cases, it was passed on the same day.
Yes, my Lord.
Impugn order in both the cases were passed on the same day. Admittedly, both the matters before the appellate authority were listed on were continuously listed on the same date, and same counsel for the assessee was representing both the matters. We have set aside the appellate order in in WP number 26904 of 24 for not following the department circular and not providing the video conferencing link to the petitioner. Next, in the instant case, the petitioner, in the instant case also, the matter was listed on 6 June 24 before the learned appellate authority. A request for adjournment on behalf of same counsel was made before the appellate authority, but because of typographical error, the appeal number was mentioned as 154/24 in bracket MD, bracket close, GST in place of appeal number. What is the correct appeal number?
154, my lord.
153. Correct appeal number 153.
It should be 153. And it is erroneously mentioned at 154. Correct number is 153.
Yes, ma'am. 153.
15 in place of appeal number 153/24 MD GST. The similar request was made through another email sent on 8th June 24 to provide video conferencing link. Next, the objection of Shri Fernandez is that this request dated 6th June 24, annexure P5 is of no consequence because this was made in a different appeal. Technically, Mr. Fernandez is correct, but we cannot ignore the typographical mistake occurred in the present case. It cannot be forgotten that both the matters were listed continuously on different dates before the appellate authority for analogous hearing. In that event, once we have interfered in the connected matter, we are not inclined to reject this matter on a hyper-technical ground. Resultantly, impugn appellate order in this case is also set aside. It will be lawful for the appellate authority to rehear the petitioner, rehear the parties and pass a fresh appellate order in accordance with law. The petition is disposed of.
Your lordship is setting any personal hearing date, my lord, or should be
You decide.
obliged?
Highly obliged. Deeply obliged.
Yes. Third. Pass over.
My lords, I appear for the petitioner in this matter, my lords.
Yes.
The matter is coming.
345. Yes, please. Yes, Mr. Petitioner.
My lords, the matter is coming for counter on behalf of the respondents. My lords, I believe the council is making certain submissions we are not able to hear.
Who is for the respondent? Counter.
Yes, my lords.
Respondent counsel, kindly unmute yourself. We are not able to hear you.
Your Lordship.
Yes.
Your Lordship.
You have to unmute yourself again.
My lords, as per the word I had with the council for respondent, my lords, they wanted to seek time to file counter, my lords.
How much time they want?
The lordships may have it 2 weeks after, my lords, on the 24th, if the lordships pleases.
All right, as prayed by respondent counsel, 2 weeks time is granted to file counter. You inform him on cell phone.
Yes, my lords, I will do the same.
One 215 matter was taken up. Na? On a request, we said we will take up at 215. That is item number. It will come in few minutes. It will come. Yes.
Lordship, this is the matter under section 179. Lordship, where the petitioner's husband was a director of the company.
Who appears for the other side? Who appears for the other side?
Lordship, Mr. Murli Krishna.
Mr. Mukherjee. Mr. Mukherjee, who is the counsel? Who was the counsel yesterday?
Mr. Murli Krishna, Lordship. He was there.
Mr. Murli Krishna ordinarily appears through video conferencing mode. Where is he? Mr. Mukherjee, we are not able to see either Murli or Krishna. What will happen? We'll keep it tomorrow. This is yesterday's matter.
Lordship, tomorrow I have a matter before the NCLT, which is date fixed. Lordship, I have it on Thursday, Lordship.
Day after.
Day after.
Okay, Shri Sarup for the petitioner, none for the revenue.
I am representing my lord.
On behalf of Shri Murli Krishna, request for adjournment is advanced. List on Thursday.
Obliged.
I beg to represent Mr. Ashwini Kumar. Sorry for my absence on the last occasion. Lord, I'll pass on list of dates as well in this matter.
Who is your opponent?
Lord, GP for services 3.
Who appears? Mr. Rahul. What is the matter about?
Lord, matter pertains.
Inform them.
Issues are a very narrow compass.
But who is appearing for the other side? If both of you are ready, we are ready to hear you. It's which year's matter?
17 months.
Lordships may kindly accommodate me, Lord. I'll inform it. Or I'll take notes of what my friend.
What is the matter in nutshell? What is under challenge before us?
Lord, it came from API team. Lord, it's a service matter. She's seeking 2 years. Lord, in Andhra Pradesh, after bifurcation, Lord, in Andhra Pradesh, the age of superannuation was extended to 60. Lord, here it was 58 in Telangana. Lord. For that 2-year period where she worked here, Lord, she was claiming salary for that period.
She worked but not getting salary.
Lord, there was an interim direction. Lord, she worked for 3 months under the interim direction. Lord. Thereafter, they refused to pay. Lord.
All right, we'll keep it tomorrow.
I'll inform them.
Parties to the council as on the request of government list tomorrow. To prepare dates and events.
It's already there.
Synopsis. Come with the synopsis. Yes.
My lord, this is the matter, my lord, where this Honorable Supreme Court has decided in our favor, my lord. Canon India judgment, Lordship may recollect. We had passed on the copies to the bench as well as the petitioner council last occasion,
Yes,
my
we
lord.
remember that. Judgment, Supreme Court's judgment. On 6/9/24, sister, both said that matter is pending in Supreme Court, therefore it may be adjourned. Similar matter. Now Supreme Court decided against the petitioner. After it stopped, lost interest. Okay, none for the petitioner even in the passover round. MS such and such for the respondent. But it is gathered that on 6/9/24, it was jointly informed by the counsel for the parties that awaiting the decision of Supreme Court in similar matter, the matter may be adjourned. That accordingly, matter was adjourned, but thereafter petitioner stopped appearing. That he did not appear on 23/10/24 and 13/11/24. That the Shri Fernandez filed the. Fernandez provided the judgment of Supreme Court In which matter?
Mal- mal- It's a review petition number 400 of 2021.
RP in bracket capital C number 400/21 in
Yes.
CA number 1827 of 18 in bracket Commissioner of Customs versus Messrs Canon India Private Limited.
Yes, Malord.
Shri Fernandez submits that curtains CURTAINS, curtains are finally drawn on the same issue by Supreme Court, and in this view of the matter, nothing remains to be, and no relief is due to the petitioner, and therefore no relief is due to the petitioner. The petitioner is absent. The petitioner is consistently absent. In view of judgment of Supreme Court and petitioner's consistent absence, petition is dismissed.
Obliged, my lord.
Kindly use microphone. Kindly use microphone.
My lordship, I am for the petitioner. Today we have received the counter. Lordship will file the reply for the counter. Kindly grant us a date.
Today you have provided copy.
Yes.
Let her have the satisfaction of filing rejoinder.
Okay.
15 days time to file rejoinder. List thereafter.
Obliged.
Obliged.
Please, Lords. Lords, this matters arise out of order passed by the National Commission.
Who is the private respondent?
Is appearing my Lord Kishore Kumar.
Not appearing against today. Mr. Kishore Kumar, anybody representing him?
As I am representing Mr. Kishore Kumar, my lord, I was informed that his father-in-law has expired, such is out of station, requested for 10 days time.
We keep it after 10 days. We keep parties to their counsel as prayed on behalf of Shri Kishore Kumar, list after 10 days.
Much obliged.
I'm being led by Senior Counsel K.V. Vikreddy. He virtually joined my lord.
Right. Did I appear for the respondent, the private respondent? Notice has been recently served. The papers, I believe, only part of them were given. Advocate on record informs me, Malad, in the morning when the matter was called, they had taken an adjournment. But because this was mentioned again and it was placed at 2:15, now I have been briefed to appear as a for the respondent.
He said that the adjournment was prayed for in his absence.
But when they did not appear in the morning when the matter was called.
First round he didn't appear.
They didn't appear,
Yes.
I believe. But in any case, Malad, I believe they have filed some additional material pursuant to the direction of this honorable court, Malad, in IA-2 of 2024. I believe they have not given it to the advocate on record. That may be given, Malad, and we will place our counter. This may be heard. Two concurrent findings, Malad, of the State Commission as well as the National Commission. Against which a 227 writ has been filed.
Malad, I appear for the petition.
What are the you are appearing for the complainant?
No, madam, I am the opposite party petitioner.
You are claimant or you are the party who suffered?
Lordships, I beg to appear, Malad.
Suffered, yes.
Malad, I beg to appear for the counsel, Mr. Bhima, who is standing. We appear for the insurance company, Malad. We stand in front of your lordships. Our case is only twofold, Malad. That the insured, the person who has taken the insurance policy, he has put a claim in front of us saying that I have suffered so-and-so loss and I've incurred so-and-so expense. And he has submitted invoices from two entities from who have to substantiate that he has incurred a loss. The insurance company directly wrote to the sales tax authorities in those two states saying that, look, we have got two invoices which says registration number, so sales tax registration number so-and-so. Is it genuine? Both the Maharashtra and the Daman and Diu, both these two states wrote back to the United India Insurance Company says that these are fake entities, these don't even exist, and that there is no sales tax registration with that number. So accordingly, we've invoked the policy on fraud. There's a clause that says that if you do fraud or suppression of documents, we are entitled to forfeit it. Now, this contention, we have raised it before the National Insurance.
Mr. Reddy, you are appearing for the claimants.
When I'm appearing for the claimant before the State Commission,
Yes, you are
respondent
appearing
number
for
2 here.
Any EP is pending.
EP
I
pending
just
on
wanted-
the 31st January is the next date, I'm told.
But in the meanwhile,
What is the
in the
urgency?
meanwhile, as an,
If you have
31st
not
January.
received the IA and copy, let you supply, we'll hear it on Monday.
I have no objection, let him take time. There's a bailable warrant against the MD of United India Insurance Company today. All I'm seeking is suspension of the bailable warrant. My friend can have it at his convenience. Let the MD not be arrested for this, Manoj.
Where is the billable?
Well, that is to be called on 31/1/2025 in execution application in the complaint case before the
But if
state.
warrant is issued,
But it is issued, Milord, as far back as on 29th November 24.
we'll stay that.
Then, Milord, may I only request this. Milord, I have succeeded at 2 places. Milord, this is a method of staying the execution petition. So the usual condition of, Milord, payment of 50% may be imposed because I have suffered, Milord, since 2002. 2002 is the repudiation of my claim. But I filed the State Commission, and State Commission first allows my claim. Then, Milord, the National Commission, Milord, remands it back. State Commission again allows my claim. Then the National Commission confirms that claim. Against that, this writ is filed, Milord, on the ground that certain letters of the sales tax authorities issued by the Bombay and Daman and Diu have not been considered. They have been specifically dealt with in the order stating that no affidavit has been filed to bring them on record as evidence. So merely some letters have been filed, so therefore that cannot be taken as evidence for the purpose of claiming their genuineness. Because no
File your
affidavit is.
counter, we'll hear you after a week and
Let
much
them
before
claim, Milord, that
much before January, but what useful purpose would be served in arresting the managing director?
No,
of
that is only in January 31st, 2025. If they are seeking a stay of that, but if they say that till 31st January, anyway there is time, they will argue it and close this matter, I have no difficulty. But if they are asking a stay even in respect of that, then
Only-
at least they should be put to the condition that they
you file
pay the
counter within
50%.
7 days, we'll keep it in the week commencing 23rd, we'll decide before January.
I'm fair enough, Manoj.
There is,
Absolutely.
Milord, I'm
Before
not,
last week of January.
but I have no difficulty on that. But Milord, once they are seeking a stay in respect of something which is not before your lordships, firstly, then there's no prayer.
prayer for stay like that.
There is no such prayer.
It
In
is
fact, I don't
suspension.
think even this has even been brought to your lordship's notice,
Where is that?
Manoj, there is a prayer, Manoj.
to my knowledge. At least, where is the prayer?
IA1.
In IA1, whether that prayer is there?
Lord, we have
In
sought
the
for
IA,
suspension.
whether such a prayer is there to stay the warrant?
No.
Manoj, Manoj, may I clarify? May I
Then
clarify?
you have to file an IA for that.
Oh, my lord, we came to know day before.
Mr. Counsel, there is a difference between an IA and a ration card. If there's a ration card, whatever comes, you will get it through that. Whether it is kerosene
Manoj,
oil, or whether it is anything. But for interim relief, you have to make a specific prayer.
Manoj, I
In the
bowed.
morning also same thing happened. We trust you. We trust the lawyers, and in the morning we inquired whether somebody said my bank account has been closed. We just inquired whether you have filed an IA, that prayer is there. He said yes, prayer is there. During lunch when I was examining, I found that there is no such prayer.
My lord, the issue is, my lord, if your lordship suspends the order.
If you are facing such a problem, file an IA.
My lord, we are pressing for suspension of the order of
My lord,
NCDRC, impugned order.
Manoj, may I step in? May I step in, Manoj? I bow down, Manoj. There is no specific.
CDRC order is of March 2024.
Manoj, there
File
is.
a fresh IA. We'll keep it in the next week. Nothing will happen till next week. And you may file your counter of
I'll
the
file
IA.
it. On 23rd, it may be taken up, Milord, the Monday.
The
So that we
only
file
issue,
counter.
the only concern, Manoj, I totally bow down by what Lordship's observations are. Only concern your Lordship knows the criminal side. Bailable warrant has come, Manoj. That's the only thing. We will. That's the only difficulty. Till a person executing a bailable warrant may not wait till January 31st. Manoj. That's the only difficulty.
31st.
You can furnish bail. Bailable warrant, you can furnish bail.
Manoj, Lordship knows arrest is a very adverse civil consequence. Manoj, like the bailable warrant. Manoj, this is the Lordship may have it next week.
All they had to do, Milord, while there is no IA, all they had to do is because they did not appear, that bailable warrants were issued. If they appear, Milord, they will be recalled. It's as simple as that. Under that guise, my lord, they are seeking a stay of this
No,
order.
it is routine thing, bailable warrant is
Yes,
issued because of non-appearance.
If they appear, my lord, it will be recalled.
My lord, I'm not seeing a stay of the order, my lord. At least at
That
this time.
copy of pending IAP provided to Sri Reddy Learned Counsel for the other side by tomorrow, list in the next week. If you want, file an appropriate IA, if you want any particular interim relief.
Obliged, my lord. Lordship, have it on 18th, my lord. If it's convenient on 18th.
By the 18th, I had a personal difficulty, my lord. 23rd, my lord, if your lordship.
23rd suits you, Mr. Vivek Reddy?
Yes.
23rd. List
Deeply
on
obliged.
23rd. Great.
The judgment of single judge and division bench is also SLP is dismissed. SLP is dismissed. Justice.
My lord, before I commence where I stopped, my lord, on 5th December, there is one more matter, my lord, which is filed today, which there was no appearance in spite of twice being called. That matter, my lord, in my reciprocal submission cannot be taken up with this, my lord, for the simple reason that, my lord, prayer is different, my lord. They seek implementation of Justice
Which is the WP?
Yes, that is WP 34600.
In item number 4, none for the petitioner, even in the pass of. But we told him that it will be taken up. He's here, I think. You are in item number 4.
My lord.
Yes. We'll hear you separately. We are not tagging with the bench.
My lord.
No, we'll hear you separately in the next week.
My lord, at least, my lord, in that we are seeking for the IA prayer, my lord.
What is that IA prayer?
My lord,
Which examination is under challenge?
my lord, the IA prayer
Which is the examination which is under challenge?
Group 1, my lord.
In group 1, we have not granted stay. They traveled to Supreme Court. Supreme Court did not interfere. We are hearing this matter and we are in the midst of the hearing. We'll keep your matter in the next week. Meanwhile, let us see what happens to these matters.
My lord, only, my lord, in that matters, my lord, to assist the court, there are some certain synopses also have been filed with this.
We'll hear you in the next week. Let this, a batch of matter is almost part heard. 70% we have heard. I think more than 70%. Now in the midst of it, a new petition is coming. We'll hear you separately. If whatever is decided here, you can take benefit of it.
My lord, after all the hearing of the matters, my lord, give me for only 5 minutes to record the contentions.
In your case, we have not put the other side to notice. There is no reply. Your matter is not ripe for final hearing. You have filed only 2 days back. And you want analogous hearing with ripe matters. What right you have?
My lord, it is also, it impacts the entire this petitions. That's what, my lord, we have also filed this data.
Then no matter can ever be concluded because people will continue to file the petitions. Their pleadings will not be over. And this entire exercise will be a futile exercise. Let us decide this judgment. If you can take benefit of that in your matter, we'll hear you in the next week.
My lord, even if that matters,
All right.
my lord.
What is your name, please?
Yeah, Ponampalli Ravi, my lord.
Shri such and such issue notice. Notices be made returnable in 4 weeks. Next.
May I please, my lord?
My lord, 2 weeks, my lord.
At least that discretion should be left with the court.
My lord,
Don't you
it
think
is
so?
only to, my lord,
Yes,
even these
we have
petitions
heard you,
have
we
not
have
main
passed it. We have heard you, we have passed the order, Mr. Next.
Your lordship, may I take up the lead matter, my lord, which I was arguing on the last occasion. That is 26038 of 24.
You argued which matter?
26038 of 24, my lord.
Yes, you are.
Mr. Sondi,
That is the lead.
that is the lead matter.
Yes.
Mr. Sondi also, though, my lord, appeared in another matter, but he argued this matter only. But I was bringing to your lordship's notice only to recapitulate, my lord, when we broke off last time. The order passed by the learned single judge, my lord Justice Karthik, with respect to a challenge mounted to the very notification itself, saying that the earlier notification ought not to have been cancelled.
That is 2/22.
Yes, my lord, 4/22.
4/22 was cancelled.
4/22 was cancelled. 2/24, my lord, is the fresh one.
So this cancellation was under challenge?
Yes, my lord. The cancellation was under challenge in that respect. My lord, I had passed on to your lordship.
Yes, yes.
Order of the learned judge and brought to your lordship's attention the prayer portion of that.
Yes.
My lord, principally, my lord, apart from the aspect with respect to questions not being framed correctly and the key, my lord, not matching, my lord, the issues with respect to the very cancellation itself, my lord, was challenged.
4/22 and 2/24 were under challenge.
Yes, my lord. The cancellation, my lord, per se was challenged.
Yes.
None of these matters. What happened? My friend was saying that we have not challenged the lead matter, we have not challenged that. No, in none of the matters it is challenged.
No, no.
But my lord, submissions are advanced.
This 2/24 is not under challenge.
No, my lord, no. And in fact, I have not advanced any argument on that.
Right, but it was under challenge before the single bench.
Yes, single bench went to division bench and up to Supreme Court also. My lord, the cancellation of the earlier notification was a subject matter of challenge before the learned single judge. My lord, I had drawn your lordship's attention to that judgment and confirmed in writ appeal. My lord, at that time, my lord, we broke off. Your lordship said that since the SLPs are listed on 6th, you come back on Monday and let us know what happened. SLPs, my lord, came to be dismissed on 6th. My lord, may I pass on a copy of the order? In fact, 27789 and 90, my lord. I have only produced 27789.
Yes. Dismissed on 6/12.
Yes, my lord. Both the SLPs, my lord, came to be dismissed. This is the order that is produced in 27789. Another one is 27790 by the same order.
Yes. Yes.
Therefore, my lord, my lord, the arguments that were advanced, not by Mr. Sondi with respect to, my lord, the order passed by the earlier, my lord, single judge, where, my lord, Justice Madhavi Devi said you reconduct the examination and then carried in appeal and then thereafter SLP being withdrawn, then, my lord, fresh notification being issued. My lord, all these, my lord, are settled by virtue of Justice Karthik's judgment because all these were argued. And, my lord, which was confirmed in appeal and, my lord, now by SLP. So, my lord, the order, my lord, per se doesn't deal with each of those contentions, but, my lord, impliedly they have been rejected, my lord, is my respectful submission, though Justice Karthik rejected on the ground of, my lord, enormous delay. There was 7 months delay, my lord, in challenging the cancellation. Similar is the case here also. One of the contentions which I have raised before your lordships is that the writ petitions are filed with delay. So, my lord, all these contentions with respect to, my lord, overreaching the order of the learned single judge, the PSC ought to have, my lord, gone back before the learned single judge, sought permission for cancellation. Instead, my lord, filing an appeal and then SLP And also the fact that during this 2 years period, several other candidates, my lord, became eligible, and about 50, 60 more posts were added to the original 503.
Yes.
All these, my lord, contentions stood rejected and now confirmed.
Yes.
So, my lord, my 5 contentions, if your lordship, my lord, to sum up, before I go into the judgments, my lord, your lordship may kindly take up my contention compilation, which I have just now given earlier, my lord. Court officer garu. Sir, contention compilation ichcharu. 512. No, not that. Just a booklet, small booklet. Yes, 512. Counter gas, sir. Contentions.
21 pages. Running in
Small booklet, my lord, comprising of 2 judgments and the summary of the parties who appeared. 512.
21 pages.
I have extra copies, but since my lords would have made notes, my lord, I am not.
No, this is not it. See, there may be flag of TP-PSC or PSC written here. Court officer, flag, TP-PSC or PSC. If I correctly remember, I mentioned TP-PSC or PSC.
Sorry, verify just single.
These were filed on 29. The lead matter is filed on 29. Yes, Mr. Ashok.
Lord, so, my lord, to sum up, my lord, firstly, challenge after participation for which, my lord, I relied upon Ashok Kumar versus State of Bihar. Page 1 of my contentions, my lord, I am inviting your lordship's kind attention. Then, my lord, recruitment in the instructions in the recruitment notification where, my lord, 29 form part of para 12. There is page first, my lord, first page of the.
I'm sorry, Ashok Kumar, which paragraph?
Beg your lordship's pardon.
Ashok Kumar, which paragraph?
Ashok Kumar, my lord, paragraph 13, 14, 15. I have written in my, my lord,
Yes,
just beside the citation.
yes.
Then, my lord, recruitment notification, paragraph 12, my lord, which contains the text of G.O. 29, my lord, State of Tamil Nadu versus Hemlata. It has attained, my lord, mandatory nature. Then, my lord, I invited your lordship's kind attention to the table to demolish the contention, my lord, that more than 10,000 people from unreserved category, my lord, were invited for mains. That is at page 5 of, my lord, my contention compilation. The table, my lord, I have invited your lordship's kind attention to show that only 3,000 people out of 31,000 from unreserved, my lord, were picked up for mains.
Yes.
Meaning 28,000, my lord, approximately were picked up from reserved category to the mains.
Yes.
Now, my lord, before I go into the question of my lord, the judgments that are relied upon, my lord, the writ petitions, all of them, my lord, a prayer is sought to, my lord, strike down G.O. 29 as well as, my lord, G.O. 96, by which, my lord, the state and subordinate service rules are amended.
Yes. Recruitment rule is also under challenge in one case.
Beg your lordship's pardon.
Recruitment rule is also under challenge.
Recruitment rule, my lord. No, no, but that's the state and subordinate service rules, Rule 22A, an amendment to Rule 22 is challenged.
A and B.
That is 96.
Yes.
That is GMS 96. GMS 96 is issued, my lord, seeking to amend Rule 22.
That is not recruitment. That is only a statement about general rules they are called as.
No, but in one case that Rule 22A and B is also.
22A and B, my lord, are part of State and Subordinate Service Rules 1996, which provide for reservation. I wanted to bring to your lordship's notice that aspect also. But my lord, this is only with respect to person.
But there are general rules, brought, and general rules are called as AP State and Subordinate Service Rules, which are applicable for all the services. And each department will have a separate rules. All are issued, but even State and Subordinate Service Rules. We are concerned with
those
state
rules are under challenge or not?
rules are under state and sub.
Yes,
Not
just wanted to add that not only GOs, one
There is a
rule,
GO.
statutory rule is also under challenge.
Yes, no, I was only responding to lordship saying, recruitment. That's not a recruitment rule. It's a state and sub.
Only to clarify, the GO by which the rule is amended is challenged. Therefore, my lord, the amendment to the rule is challenged. In that sense, the rule itself is challenged because the rule as now is amended. So the amended rule is under challenge. But before I take your lordships as to what was argued with respect to 96, my lord, what is notable here is, in 4 matters, my lord, the question of 96 was not even argued. None of the counsel argued, my lord, with respect to 96. Nothing was submitted before this court. They argued 29 and they rested their cases. That is, my lord, release.
No, you both of you address the court. Don't address to.
I'm sorry. No, he is not there in that 4 petition list. My friend is not thinking that I'm addressing it to him.
If your friend is incorrect, during your argument, you inform us. Yes.
So, my lord, in 4 writ petitions, that is, my lord, WP 23775 of 24, 28488 of 24, and party in person 23907 of 24, and my lord, AOR Mr. Kaushik 28576 of 24. In all these 4 matters, 28576 of 24.
GO 96 is not challenged.
Not challenged, but not argued.
Yes.
Though, my lord, Mr. Madan Mohan Rao spent more time than Mr. Sudhir, but both of them, my lord, devoted about 5 to 10% of their arguing time for 96. My lord, 96 is what, my lord, brings the jurisdictional facts before this court. And I will also demonstrate, my lord, as to in what context the 96 had to be issued. My lord, we'll go there a little bit later. But my lord, my reciprocal submission is that when the very maintainability of the writ petition before a division bench of this court, my lord, is available only if there is a challenge to a rule. Because 29 alone, my lord, would have taken it before the learned single judge. I am not saying they should argue there, they should argue here, but kindly see the modus operandi to
rule is under challenge.
Rule is under challenge, but my lord, how can a rule be challenged and not argued and something else argued and my lord left it at that?
Somebody challenged the rule and argued also.
It is no, that is what I am saying. So, except Mr. Madan Mohan Rao and Mr. Sudhir, none of the counsel have argued, my lord, the challenge to the rule. On what basis?
We will not decide on the majority.
I need to bring to your lordship's notice.
If even a single person challenge the rule, all linked matters will be heard.
In fact, my lord, if I recall, my lord, correctly what your lordship asked at the interlocutory stage, as to show us as to how did you lay the foundation for challenge to the rule, number 1. And the important aspect is none of the petitioners are physically disabled. And how come they are interested in challenging, my lord, the reservation which is provided for them? This is what, my lord, was the question posed. But, my lord, the fact of the matter is that 96 was not argued. I will show, my lord, how it has a bearing on the whole thing. My lord, I understand it is under challenge. Your lordship will have to deal with the pleadings. My lord, in this situation, now kindly see, my lord, the judgments that are relied upon. Firstly, my lord, the inspiration appears to be from, my lord, your lordship may take up the compilation given by Mr. Sodhi, my lord. On 312, అదే కోర్టు ఇచ్చారు. My lord, the inspiration, though appears to be the prayer, my lord, they say Dipendra Yadav. inspiration appears to be Kishore Chaudhary. This is my lord, my understanding of the matter. So my lord, my endeavor before your lordships would be to pursue your lordships to hold that neither of two judgments, my lord, have any relevance whatsoever to the current matter. Firstly, my lord, kindly take up Kishore Chaudhary, which commences at page 24, a judgment of the Divisional Bench of the Madhya Pradesh High Court, page 24, my lord. Yes. May I invite your lordship's kind attention to page 27, paragraph 2. Kishore Chaudhary was not under, my lord, consideration in Dipendra Yadav. Your lordship has seen that. A subsequent judgment, my lord, was under challenge. Page 27, my lord. Firstly, para 1, my lord. Few writ petitions of this batch of 49 petitions are filed, assailing constitutionality of subsection 4 of section 4 of Madhya Pradesh Lok Seva अनुसूचित जातियों, अनुसूचित जनजातियों और अन्य पिछड़े वर्गों के लिए आरक्षण अधिनियम 1994. Whereas the rest of them are filed with a prayer to declare Rule 4.3d Roman 3 of Amendment dated 17 February 2020 in Madhya Pradesh State Service Examination Rules 2015 as ultra vires. The admitted facts between the parties are that the Madhya Pradesh Public Service Commission published an advertisement on 14/11/2019 for conducting State Service Examination 2019 for a total 571 posts, including the post for reserved category. In furtherance thereof, the petitioners submitted their candidature in prescribed form for appearing in the said examination. On 12/1/2020, preliminary examination was conducted by PSC. Soon thereafter, the impugned amendment in the rules came up into being by publishing it in official gazette on 17/2/2020. The result of the said examination was declared on 21/12/2020 on the basis of amended rules of 2020. Aggrieved, these batch of writ petitions were filed. In these petitions, the respondents were put to notice and in turn they filed reply. After receiving notices in the petitions, yet another amendment dated 20/12/2021 was published in the official gazette on 20/12/2021, amending the said examination rules. On 31/12/2021, the PSC declared the result of the said examination and proceeded further to take interview of the candidates. My lord, these are the facts, my lord, under which this matter arose. My lord, what comes out of this is firstly, the preliminary examination was held in terms of the unamended rule. After the conduct of the examination, the rules were amended. After the filing of the writ petition, the amended rules were once again amended. My lord, this situation in my respectful submission does not arise before your lordships. It is, my lord, I can see it is far more complicated than what is there before your lordships because 3 mains examinations were conducted, my lord, in Madhya Pradesh. In pursuance to the amended rules, unamended rules, and my lord, the normalization aspect was gone into by the Supreme Court in Dipendra Yadav. The committee was, my lord, called to explain, and the Supreme Court was satisfied with the process of normalization. My respectful submission before your lordships is that there is no rule whatsoever, neither 96 nor 29, have been issued after the prelims was conducted. And there is no question, my lord, of any change in the rules of the game once the game has commenced. Therefore, my lord, in my respectful submission, Kishore Chaudhary facts are entirely different. Now, kindly see, my lord, as to whether those rules, my lord, are also anywhere, my lord, in anywhere near to 29. Kindly see page 29, paragraph 8. It is common ground taken by all the petitioners that the selection process started with issuance of advertisement on 14/11/2019. As per the rules prevailing at that point of time, the respondents were obliged to treat the reserve category candidates who have secured marks equal or more to a UR candidate as UR candidate at all stages, including preliminary and main examination. This procedure laid down in the main rules could not have been changed to the detriment of petitioners after game was started. In nutshell, it is argued that rules of game cannot be permitted to be changed after commencement of game. This is what, my lord, I had submitted before your lordships. Then, my lord, Saurav Yadav is relied upon at paragraph 17 at page 31. While extracting the contentions of the petitioners, because they are relying upon Saurav Yadav, I am bringing this to your lordship's notice. Now kindly see the findings of the division bench at page 32, paragraph 25.
Yes.
Constitutionality of section 4.4 of the Adhiniyam. Kindly see, my lord, what is the rule that is challenged? The petitioners have raised eyebrows on the expression "get selected" used in this provision. Section 4.4 reads as under. If a person belonging to any of the categories mentioned in subsection 2 gets selected on the basis of merit in an open competition with general candidates, he shall not be adjusted against the vacancies reserved for such category under subsection 2. My lord, this is what is there. Now kindly see para 26, my lord. A division bench of this court in the case of Srimati Rajshri Tiwari versus State of Madhya Pradesh appoint that subsection 4 of section 4 of the Adhiniyam of 1994 is in consonance with the interpretation of section 16.4 of the Constitution given by the Supreme Court in the case of Indra Shawni. In this backdrop, we are unable to declare subsection 4 of section 4 as unconstitutional. My lord, this is the finding of the division bench with respect to 4.4 which is extracted in para 25. Now, my lord, kindly see what is the import of G.O. 25, my lord. I will have to pause here, my lord. It is necessary to see what 29 says and what does the amendment say. Before that, may I invite the lordship's kind attention to 55 first at page 168 of the writ petition compilation.
$160.
168, my lord.
Yes.
Kindly come to, this is where 55 is placed. Kindly come to page 171, my lord. Capital paragraph B.
Yes.
The number of candidates to be admitted to the written examination would be 50 times to the total number of vacancies available in each multi-zone, duly following the reservation for community, gender, EWS, physically handicapped and sports, as laid down in General Rules 22 and 22A of TS State and Subordinate Service Rules. This is what, my lord, 55 said. Now kindly see what 29 says, how it amends paragraph B at page 178, 10 pages later, my lord.
Yes.
178 bottom. The number of candidates to be admitted to written examination would be 50 times to the total number of vacancies available in each multi-zone. Provided that, my lord, this proviso is created by 29. Provided that, in case of any shortfall in respect of candidates in reserved categories as laid down in Rules 22 and 22A of Telangana State and Subordinate Service Rules 1996, action shall be taken to include such number of candidates from the merit list beyond 1:50 ratio as required to meet the shortfall in the respective categories. This, my lord, is challenged before your lordships. My lord, this is nowhere near to section 4.4 of the Adhiniyam 1994, firstly. Because, my lord, there is a specific provision as to how to deal with that situation. Now, it is also required, my lord, since both 55 and 29 also speak about 22 and 22A. Now, let us see whether 22 also, my lord, is anywhere near 4.4 of the Adhiniyam. My lord, lordship's kind attention to the State and Subordinate Service Rules. Books time. Kindly go to page 37 of the booklet, madam.
Yes.
22.1. The reservations may be made for appointments to a service, class or category in favor of scheduled castes, scheduled tribes, socially and educationally backward classes, women, persons with disability, meritorious sportsperson, ex-servicemen, and such other categories as may be prescribed by the government from time to time to the extent and in the manner specified hereinafter in these rules, or as the case may be in the special rules. The principle of reservation, as hereinafter provided, shall apply to all appointments to a service, class, or category. Then, 222, 1, small Roman 1. By direct recruitment, except where the government, by general or special order made in this behalf, exempt such service, class, or category. Then, otherwise we are not concerned. Then, 22, 2A1. The unit of appointment for the purpose of direct recruitment shall be 100 vacancies, of which 15 shall be reserved for scheduled caste, 6 shall be reserved for scheduled tribes, 29 shall be reserved for socially and educationally backward classes, and remaining 50 appointments shall be made on the basis of open competition and subject to Rule 22A of these rules. Then, 22 2A2 deals with promotion. We are not concerned. Rest of the rule, perhaps may not be relevant for the present inquiry. 22 2A1 clearly shows the manner in which the reservation has to be provided. Whereas, 4.4 says, if a person belonging to any of the categories mentioned in subsection 2 gets selected on the basis of merit in an open competition with general candidates, he shall not be adjusted against the vacancies reserved for such category under subsection 2. This is what the adjournment says. In a utopian world, I would say we could have done with better rules. Right now, there is no such rule here. What all there is 55 as clarified by 29, which says follow 22, 22A. I have shown you lordships what 22, 2A1 says. It says these are the reservations, you have to follow this. This is what 55 said, 29 also says. In fact, 29 goes a bit further. It says if after you go through 22, if you find that there are certain candidates, certain categories which have not been up to the mark, then you go further down and pick them up. And I have shown you lordships the table by which it is very clear that in a group of 31,000 people who got selected, 28,000 are from reserved category. It is very clear, my lord, 29 is inuring to their benefit only. Now kindly see 22A also at page 45. This is specifically with respect to women. Notwithstanding anything contained in these rules or special rules or ad hoc rules, in the matter of direct recruitment to posts for which women are better suited than men, preference shall be given to women, provided that such absolute preference to women shall not result in total exclusion of men in any category of posts. Then, in the matter of direct recruitment to posts for which women and men are equally suited, there should be reservation to women to an extent of 33 1/3 of the posts in each category of open competition. Socially and educationally backward classes group A, socially educationally backward classes B, C, D, E, scheduled caste, scheduled tribes, and persons with disabilities and ex-servicemen quota. Then 3. In the matter of direct recruitment to posts which are reserved exclusively for being filled by women, they shall be filled by women only. Then 4 deals with promotion and appointment by transfer. Therefore, my respectful submission before your lordships is that both 55 and 29, they speak about 22, 22A. It is nowhere near to a provision like 4.4 of the Adjournment 1994. Therefore, that judgment is not applicable to the facts of our case. So kindly see the comparative table which the Divisional Bench drew with respect to amendment. Now let us see whether any at page 35, paragraph 33, where constitutionality of rule 4.3D Roman 3 of the examination rules, is extracted.
It's in bold letters.
Beg your lordship's
pardon. In bold letters.
Yes, my lord, in bold letters.
Yes, 37.
Page 35, para 33, my lord.
But the offending portion is reproduced at page 37 in the middle column.
Yes, in bold. Yes, I am blessed. Yes, yes. I am carrying coal to Newcastle, my lord, but I have to show your lordships. This is the begins at, I am obliged, my lord.
It was highlighted in fact.
Yes, yes. This is what is highlighted but above adjustment will be only at the time of final selection and not at the time of preliminary or main examination. This, my lord, in my respectful submission does not exist in our matter at all. Now kindly see how the division bench saw the main rule and the amendments at page 38 after the table extraction. A comparative reading. My lord's got it, my lord. Paragraph. Page 38, just above para 34 after the table. A comparative reading of main rule and two subsequent amendments above makes it clear that as per main unamended rule, the meritorious reserved category candidate was entitled to compete with UR category candidates and get his position in open UR category. By impugned amendment dated 17/2/2020, this right was taken away by confining the benefit at the time of final selection only. This is not there in our case. By subsequent amendment dated 2012-2021, the earlier position prevailing at the time of unamended rules was restored. Thus, the impugned amendment became a hurdle for the meritorious reserved candidates to be treated as UR open category candidate. Then your lordship have said about Indrashani, which we have no merit quarrel. That is stated in para 44 at page 42. Para 44, second paragraph. We are of the considered view, lordships got it, that the principles laid down by the Supreme Court in Indrashani can be translated into reality only when reserved category candidates secure equal or more marks with unreserved category candidate in given birth in UR category in all stages of selection, including preliminary and the main examination. Any other interpretation would defeat the purpose and the constitutional scheme flowing from 14 and 16 of the Constitution of India. There is no justifiable reason for depriving a meritorious reserved category candidate who has competed with UR category candidate and secured same or more marks than from being treated as UR candidate. Then at the end of that paragraph, your lordship said we accordingly at page 43, just above para 45, we accordingly declare rule 4.3d3 of the amended rules as unconstitutional. Now, the correctness of this was subsequently doubted by a coordinate bench of the Madhya Pradesh High Court.
Is it a bench headed by Honorable Justice Sheel Nagu? Is it a bench headed by Honorable Justice Sheel Nagu?
My lord, I have that. There is another judgment, my lord, which considered both these judgments. This judgment is on 21st November 24 by Chief Justice Kait and Justice Vivek Jain. Another division bench order.
The recent one.
This is the latest one. I'll just pass on. जो कोई भी है. My lord, this is with respect to recruitment in the judiciary of Madhya Pradesh. The first page, my lord, the prayer is extracted. Kindly go to page 3, my lord. A coordinate bench of this court in Kishore Chaudhary, para 45 is extracted. Later, another coordinate bench of this court in Pushpendra Kumar Patel and others versus State of MP and others in so and so taking contrary view, held as under.
Just a minute.
Yes.
In this subsequent judgment, do you have this Pushpendra Patel with you?
I'll pass on.
This must be by a bench headed by Honorable Justice Sheel Nagu.
Yes, I'll just pass on. Right now I don't have it. I'll ask my colleague to take.
Then how the recent bench held?
Yes, the recent bench, WP 8750, Jabalpur bench. Kindly go to para 8. It is pertinent to mention here. I am reading page 3, para 8, my lord.
Yes.
It is pertinent to mention here that recently the Honorable Supreme Court of India, In the case of Dipendra Yadav and others versus State of Madhya Pradesh, then my lord, para 30 onwards is extracted. Kindly come to page 5, paragraph 9. Yes. The Honorable Supreme Court in Dipendra Yadav has approved the legality and validity of extending the benefit of migration to meritorious reserved category candidates in unreserved category in all stages of selection as held by coordinate bench of this court in Kishore Chaudhary. Therefore, my lord, I can say that it is again quoted approvingly. Then in view of the above, we direct that henceforth in all future recruitment exams conducted by examination cell of High Court of Madhya Pradesh, benefit of migration shall be extended to meritorious reserved category candidates in unreserved category in all the stages of selection process. It is however clarified that ongoing recruitment examination conducted by the examination cell wherein examination, preliminary or mains as the case may be, has already been conducted shall not be affected by this order. My lord, this is brought to your lordship's notice only to show the development, my lord, in that aspect. Though, my lord, we are nowhere concerned with all those three, my lord, division bench judgments. I'll give the complete judgment of the second coordinate bench, my lord. Therefore, my lord, as far as Kishore Chaudhary is concerned, because of the fact that the rules, the examination rules, my lord, or the adhiniyam, none of them, my lord, are anywhere connected to either 29 or Rule 22. Those judgments, my lord, in my respectful submission are not applicable. Nextly, my lord, kindly go to Daria, my lord, was extensively quoted, my lord, in the affidavits of most of the parties. Rajesh Kumar Daria, before I show Dipendra Yadav, this is 2007, compilation, my lord, page 83. Judgment compilation, page 83. Only one para, my lord, I would like to invite your lordship's kind attention. Page 87 of the compilation, my lord. Paragraph 5. Yes. Rule 9.3 of the Rajasthan Judicial Service Rules 1995, which is relevant, reads as follows. 9.3. Reservation for women candidates shall be 20% category wise in the direct recruitment. In the event of non-availability of eligible and suitable women candidates in a particular year, the vacancies so reserved for them shall be filled in accordance with the normal procedure, and such vacancies shall not be carried forward to the subsequent year. And the reservation treated as horizontal reservation, that is, the reservation for women candidates shall be adjusted proportionately in the respective category to which the women candidate belongs. My lord, this is the rule which fell for consideration before the Supreme Court in Daria's case. Now, we have no quarrel with this. Even in our state, my lord, the very same thing is being implemented. Pursuant to this, our rules were amended. Now, kindly see where is the mention with respect to physically handicapped, my lord. Para 9 at page 790, the running page 88, my lord. Paragraph 9. The second relates to the difference between the nature of vertical reservation and horizontal reservation. Social reservations in favor of SC, ST and OBC under Article 16.4 are vertical reservations. Special reservations in favor of physically handicapped women, etc. under Article 16.1 or 15.3 are horizontal reservations. Except this sentence, Daria does not in anywhere deal with the question of reservation for physically handicapped persons. Except this sentence in paragraph 9. But this is nothing but obiter. This has no binding precedence whatsoever, my lord, with respect to the issue at hand. Because the Supreme Court also was concerned with Rule 9, which deals with reservation for women candidates. Now may I invite your lordship's kind attention to Dipendra Yadav, my lord, which is the sheet anchor of the petitioner's argument. It commences at page 45. May I invite your Lordship's kind attention to page 48, paragraph 1.
Yes.
Leave granted only in SLPC number 5817 of 2023. Lordship got that minute? Kindly see what this SLP is about. That is at paragraph 11, page 53.
Yes.
While so, some candidates filed WP through 23828 of 22 before the High Court of Madhya Pradesh at Jabalpur, assailing the decision of the MPPSC to cancel the result of the main examination held earlier on the ground that they would be required to reappear for the said examination despite clearing it in the first instance. The petitioners in SLP number 5817 of 23, from which this appeal arises, intervened in the said petition and they were also heard. This writ petition was filed on 13/10/2022. Therefore, my lord, the substantive writ petition is 23828 of 22, my lord, which is again with respect to assailing the cancellation of the examination. My lord, the situation does not arise here. There is no cancellation whatsoever. Now, my lord, kindly see. Your Lordship knows, my lord, the history, since, my lord, your Lordship have extensively dealt with it. In Kishore Chaudhary, my lord, the Supreme Court had extracted the history at page 48, paragraph 3, line about 5 from bottom. Exactly what your Lordship, my lord, said at paragraph 2, my lord, somewhat similar words. The preliminary examination took place on 12/1/2020. The total number of candidates who registered for the preliminary examination stood at 3,64,877, but only 3,18,130 of them actually appeared for the examination. At that stage, on 17/2/2020, Rule 4 of the Rules of 2015 was amended by State of Madhya Pradesh. Then, my lord, Rule 4 is extracted. The effect of Rule 4, my lord, is extracted, is stated in para 5, page 50. Paragraph 5, my lord, page 50.
Yes.
In effect, the amended Rule 4 of the Rules of 2015 provided that adjustment and segregation of meritorious reservation category candidates with meritorious unreserved category candidates would be only at the time of final selection and not at the time of preliminary main examination. 6, my lord. Surprisingly, the amended Rule 4 was applied to the ongoing recruitment process relating to notified 571 vacant posts. The result of the preliminary examination conducted on 12/1/2020 was declared on 21/12/2020, applying the amended Rule 4. Thus, there was no segregation of meritorious reservation category candidates with those from unreserved category candidates, and they were shown in their respective reservation categories only. The number of candidates who cleared the preliminary examination on this basis was 10,767. Then, my lord, Kishore Chaudhary is quoted at paragraph 9, page 52. Notwithstanding this amendment, the result of the main examination held between 21/3/21 and 26/3/21 was declared by the MPPC on 31/12/21, and the number of candidates who provisionally qualified for interviews was 1,918. However, by judgment dated 7/4/22, a division bench of the High Court of Madhya Pradesh at Jabalpur partly allowed the pending writ petitions, namely WP so-and-so and batch titled Kishore Chaudhary versus State of Madhya Pradesh and another. Challenge in this batch of cases was not only to the validity of amended Rule 4(3)(d)(3) of the rules of 2015, but also Section 4(4) of the Adhiniyam. Then, my lord, 4(4) is extracted. My lord, the order in WP 23828 of 22 before the Division Bench of the Madhya Pradesh High Court is extracted at para 14, page 54. This is what, my lord, the learned judge did. The learned judge observed that if the result of the main examination was cancelled, a premium would be given to the candidates from the 4th category by reviving their candidature. Before that, my lord, in para 13, the the type of candidates that emerged in view of the amendment to the rule and conduct of three main examination is extracted by the Supreme Court. Then, though not relevant, I'm just by reviewing their candidature, though they had failed to qualify in the first instance, and the right could be taken away from candidates who had already cleared the main examination and qualified for the interview. The learned judge opined that this would cause serious prejudice and grave injustice to candidates who were declared eligible and had qualified in the shortlisting process, and that holding the entire main examination afresh would not only result in incurring huge costs but also cause grave injustice to a large number of candidates who had already cleared the main examination and were shortlisted for the interview without any fault on their part. Holding so, the learned judge invalidated the decision taken by the NPPC on 10/10/2022 proposing to hold a fresh main examination by cancelling the earlier one, and directed the NPPSC to hold a special main examination as was done by it earlier on several occasions for the new eligible reservation category candidates as per the redrawn preliminary examination result. The learned judge directed that on the basis of the results of these two main examinations, a fresh list of selected candidates should be prepared in terms of the rules of 2015 for the interview by merging and normalizing the two lists as per the process adopted by the NPPSC on previous occasions. This exercise was directed to be completed within 6 months. My lord, this is the list, my lord, from which the SLP arose before the Supreme Court in Dipendra Yadav. Paragraph 14. But my respectful submission is, my lord, this situation is not there before your lordships at all. The facts are completely different. No question of any three main examinations being conducted, three different lists, cancellation of one of them, though the petitioners tried their best at the interlocutory stage to ensure that the main is not conducted. Unsuccessfully though. Then, my lord, in this situation, now kindly see the observations which the petitioners seek to rely, paragraph 30 at page 59. It is far, far, far more complicated, my lord, what happened in Madhya Pradesh. My lord, and it was also sought to be justified and successfully though, my lord, I could not understand how the normalization could take place and how the reserved category candidates would be adjusted against which post, my lord. That situation fortunately doesn't exist here. Para 30, page 59. We may also note that Rule 4.3d Roman 3 of the rules of 2015 patently harmed the interest of the reservation category candidates, as even meritorious candidates from such categories who had not availed any reservation benefit relaxation were to be treated as belonging to those reservation categories, and they were not to be segregated with meritorious unreserved category candidates at the preliminary examination result stage. As a result, they continued to occupy the reservation category slots which would otherwise gone to de-reserving reservation category candidates lower down in the merit list of that category, had they been included with the meritorious reserved, unreserved category candidates on the strength of their marks. Then, my lord, the operative portion, page 61, para 34, second paragraph. The civil appeal arising out of SLP 5817 is therefore bereft of merit and is accordingly dismissed. If your lordship would see the observations of the Supreme Court from para 30 onwards, though we have no quarrel, we are not saying we are not following that. We are not saying we are depriving at all. As my lord shown, the data itself shows, my lord, the question of deprivation doesn't arise. 28,000 out of 31,000, it is very clear, my lord, that the reservation category candidates have been taken care of amply. And all of them, my lord, are eligible to compete, my lord, in mains against open category only. There is no, my lord, quarrel with respect to that also. Para 14, your lordship have seen what is the subject matter in the writ petition and how the learned judge dealt with it and what was the SLP before the Supreme Court. Therefore, my lord, the facts of the case, Kishore Chaudhary and my lord Dipendra Yadav, though not directly in my lord, challenge before Supreme Court, they both arise out of the same fact situation, and that fact situation is not existing, my lord, in the present case. In fact, G.O 29 is brought in to avoid that situation. That is what Balaji Badawat paragraph 43 says, which I have invited Milord earlier. I don't want to repeat on that, Milord. So, Milord, my friend Mr. Sudhir, Milord, this answers my Milord submissions with respect to Mr. Aditya Sondhi's contentions and Mr. Madan Mohan Rao's contentions with respect to 55 and 29. And Milord, especially Mr. Sondhi's arguments that the Public Service Commission should not have followed 29, we should have gone back before Justice Madhavi Devi. All that, Milord, is water under bridge. I have already answered.
Reconduct.
Beg your lordship's pardon.
The emphasis on the word reconduct the exam.
Yes, reconduct, yes, on the aspect of reconduct of examination. Now, my lord, coming to the question of my lord, my friend Sudhir's submission that this whole thing is done, that is the cancellation as well as the re-notification. Though, my lord, I couldn't find the submission in the pleadings, which, my lord, he has filed. He is very elaborate, my lord, in his pleadings as well as prayer. That due to change in the political scenario, my lord, this has come about. Well, I fail to understand, my lord, what is the basis for this submission, firstly. Now, my lord, to give it back to him, not my lord, necessarily the same words, this entire thing appears to be, my lord, politically motivated. Your lordship may see. I have shown the list where participants who have qualified the prelims are before this court, without saying, my lord, what is their concern. And in fact, Mr. Sudhir's case, my lord, they filed after the mains was conducted. They wrote the mains examination, thereafter they filed the writ petition.
That is WP number?
WP number 32482 of 24. 32482 of 24. Three of them, my lord, did not qualify.
19th of November 24.
Yes.
Both kinds are there.
I am not denying. Three did not qualify. Two qualified.
Yes,
I have shown the statement.
It is filed on 19th November.
Correct. Yes, not all that. My friend is saying all of them have.
No, I didn't say all. I'm sorry. Statement itself.
I'm only trying to say about there are two types of people.
Yes.
Category A, category B, which are explained.
Yeah. When I showed Ashok Kumar, your lordship posed a direct question to me, does that situation arise here? The challenge after participation principle can you put against a person who is successful? Because, my lord, normally what they say, challenge after participation, if you are unsuccessful, you cannot because you know the process even before you commenced. Then I said, possibly to get over that, my lord, people who are passed are also included. But, my lord, posing a question to myself, how do you deal with those people who are failed? I have given.
The question is hypothetical question, but suppose it is few at the behest of few petitioners who were successful, petitions are maintainable. And suppose they succeed, everybody will get benefit.
But
here the G.O is under challenge.
Yes.
In case at the behest of successful candidates, we agree, suppose. So hypothetical question.
Yes,
yes. Then G.O will go for everybody.
But that would mean.
We will not say that it is quashed for successful candidate and it is applicable
that is true. That is true. But that would mean. Lord, your lordship would have to, I am not saying hypothetically again.
In other words, there are few persons, those who have locus to challenge.
Or my lord, contrarily, let me put it like this, my lord. Again, hypothetically, my lord, I am saying. Your lordship would have to negative our contention that people who participated and failed cannot challenge. In case if your lordship would have to agree with those people who succeed, my lord, in spite of the fact that they participated, your lordship would have to negative our contention that those who have did not succeed, my lord,
we will deal appropriately.
No, I know that, my lord. Since your lordship has said hypothetically, I am also saying hypothetically. I have no doubts with respect to that, my lord, that your lordship would deal with all this. I have no doubts whatsoever. Since your lordship said hypothetically, I am only saying this because I said to get over Ashok Kumar, my lord, people who are successful are brought on. Is what I submitted before your lordships, and for that, my lord, it is for them to explain to your lordships what is the grievance that they have. I can understand a person who failed, my lord, who cannot get employment. Person who passed is also before your lordships, my lord. That is where the political scenario aspect would come into play. Very clearly. My lord, I'll just pass on, my lord, this judgment of the division bench. Your lordship just now requested. Though I must say I didn't read the whole judgment, my lord.
This is,
Justice Sheel Nagu and Justice Virendra Singh.
I am aware of that.
Your lordship just now asked, my lord, sir.
Because in the recent judgment by Justice
Suresh K.
Chief Justice,
Yes, K.
It has been said that Kishore Chaudhary will be followed henceforth.
Yes.
Not
yes.
this one.
Yes, yes. yes.
I remember because it's from my parent High Court.
Yes, yes, my lord.
I know the.
No, since your lordship asked me 5 minutes ago, I requested my colleague to get copies. So that,
But after that, when you read that judgment of Honorable Justice Kat,
of Chief Justice
the
K.
relevant portion of this judgment is also reproduced.
Extracted there, yes.
So I could lay my hands then and there only.
Yes.
You may continue tomorrow.
Very well, my lord. I have concluded, my lord. My friend Rahul will.
Tomorrow, Mr.
Yes.
Rahul. Tomorrow. Parties through their counsel. Hearing in this part heard batch commenced. Shri Rajshekar, learned counsel for TPPSC, concluded his arguments because of paucity of time. List tomorrow as a part heard matter. Immediately after motion. 395 post tomorrow. This matter may consume whole time. So take your chance. If time permits, we'll hear you. Take chance because without concluding this, we'll not be able to switch over to other matters. Yes.